Thank you. So, I don't have a third respondent. Yes, we've seen those. Sorry, it wasn't drawn. I'd assumed that they were part of the replying papers.
Notice is that item 4 on page 181.
Fourth respondent. It's a duplication of an earlier page.
That's unfortunately
Would you mark it as 182 capital A? One. You handed up earlier, Mr. Where would you like to put that in? Inserted at an appropriate place before the replying affidavit? No, I prefer to put it chronologically, perhaps at the end of, after Mr. Smith's affidavit. Certainly. A, B, and C. Mr. Breitenbach, so what is the attitude of the city manager in the city? Very well. Any of the other parties have any difficulty with the filing of these late papers? No problems? Just to repeat on the record what council were informed in chambers, the Judge President has directed that the Part B relief in this matter be heard by a full bench of 3 judges of this division in 2 weeks' time on Friday the 25th of May. So as I understand it, all of the parties are agreeable to the relief sought in paragraph 2.3 of the notice of motion. And that relief will be granted together with the postponement of the matter until the 25th of May. What remains then is the question of interim relief. So, is the position then that the position of mayor is currently filled by the deputy mayor, as in an acting capacity?
Filled, well, in our version it's not really properly filled, but yes, there is an acting mayor, face value at least.
Mr. Nielsen, is it?
Mr. Nielsen, correct, fellow. And the allegation in Mr. South's affidavit was that there he had confirmed about appointing a Maker, which has now just been corrected.
So there are no new members of MACO appointed, and in terms of the DA's understanding of it, the existing MACO was dissolved with the termination of the membership of your client.
Well, that's an interesting question. Whether it would have been dissolved by termination or dissolved by the appointment of the new Maker, but I don't think that's a question that we need to.
Well, it is an important point from the balance of convenience point of view, because the argument that's put up is that the city will have an old MACO, a new MACO, and then another MACO. If the parties could inform us as to whether a practical arrangement could be achieved in that regard, I suppose it rests really with Mr. Rosenberg and his side. That may assist us in determining the matter.
I propose just to save time, we can do that during one of the breaks.
Yes.
And then we'll inform the court.
Yes.
Let's go.
Yes, I had in mind sitting till about 11:30 to take a short break. If you could finish in an hour, we'd appreciate it, because this is the fast track of the urgent court today. There are other matters. While you're on your feet, Mr. Mpofu, we note from the papers that neither party takes the point of urgency. That may be because it's expedient for both parties to have the matter determined today. But the provisions of Rule 65G are quite clear. An applicant for urgent relief has to make out a case for urgency, and she has to allege, in terms of 65G, it's obligatory, she has to allege that she will not be able to get effective relief in due course. I do not see any such allegation in the applicant's papers, but I leave it to you to deal with at your discretion. Thank you.
Yes. Well, first I'll start where the protest started, namely that it would seem, subject to what my learned friends have to say, it would seem that the question of urgency is not an issue considered or at least taken for granted, judging the answering affidavit of moving
The question of urgency is particular matter presents itself in a slightly different form. The points taken of the first responder, the urgency of seeking. The first responder's contention is that obtaining interim relief at this stage is an inappropriate remedy. The proper and available remedy is a review court on a abbreviated term time. So in a sense, that is dealing with the need to hear the matter for relief today, on the assumption or the contention that in fact relief in the immediate short term is neither necessary or appropriate. So that also goes to the question of urgency.
Thank you. Mr. Mpofu?
Well, I don't think I understand what happens. My understanding from what they say in their papers is that because the matter is urgent, they were prepared to have it heard within a short space of 2 weeks, which now has been taken care of by what the court has informed us. And for that same reason, they did not take the point of urgency. But for what it's worth, it doesn't look like there's going to be a debate on urgency per se. But as to whether the necessary amendments have sufficiently been made, I will deal with it maybe towards the end of my argument, if it's still necessary. Right. Now, what I wanted to say by way of housekeeping at this stage is that my learned friend and junior, Mr. Deval, we're going to split the presentation, and I have asked him to go first, because part of what he's going to cover is the factual background with which he has been engaged in this matter for the past 6 months. The second issue that I need him to deal with, and the factual background anyway, is important in this matter for various reasons. One, because it is part of the interpretation issue, which I will deal with, but also just to familiarize the court. The second issue is the issue of what the other side has called in their heads technical non-compliance, or what we prefer to call jurisdictional facts, the absence of jurisdictional facts for the application of the relevant rule of the DA Constitution. Mr. Duval will expand a bit on that. And then, either separately or as part of the factual background, Mr. Duval will also deal with what we might call, for shorthand, the Makaiza interview, the radio interview that brought us all here.
Yes, I think it was said in the, I'm going to refer to the parties by their names, but in the DA's papers that there's a transcript of the Makaiza interview available. We were given a link to the, what do they call it, podcast. I've listened to it, my colleague hasn't. I think we would both prefer to have full transcript of that interview, if it's available in 2 copies.
Yes, I'm sure it is. If it's not arranged, we would also appreciate it.
Thank you.
Then what I will do with, I will start with dealing with the preliminary point about the horses bolted and followed. The submission that Mr. Rosenberg was alluding to now about the appropriateness of interim relief in the first place. Then I'll deal briefly with the interpretation, proper interpretation to be placed on the Makaiza interview. And then the real issue that of substance that I'm going to do the constitutional and legal grounds for this application. And with the permission of the court, I prefer to do that under the rubric of the requirements for interdict. In other words, I'll put in whatever constitutional issues within that.
Yes, you're welcome to choose whatever course you wish.
As court. But before I hand over then to Mr. Duval, I'd just like to maybe signpost where we're going. By simply saying that the facts of this matter are deceptively simple, but actually there are serious questions of principle, policy, and constitutional law that underlie the matter. But of course, no doubt, in 2 weeks' time, those issues will be fully ventilated before the full bench, as it has been kindly indicated. And those facts really go around this simple question. Given the constitutional context and everything that we will talk about, or that has been alluded to in the papers, can the words used by Ms. Lille in the Makaiza interview on the 26th of April really justify her hurried removal on the 8th of May 2018? That's really it. It's all going to be an answer to that question.
Interview was on the 25th?
26th April, the utterance, the actual utterance. And the removal, purported removal or cessation of membership, 8 May. Now, that's what sounds like a very simple matter or question to answer. Until, of course, we realize that purported removal does the following 3 things. It removes her from the membership of her chosen political party, which, as I will explain later, deals with the rights which are enshrined in Section 19 of the Constitution of all citizens to choose a political party of their choice, or rather to join a political party of their choice. So that's the first thing it does. The second thing that it does is to take her from the position of a councillor, to which she has been democratically elected by the citizens of Cape Town, and that then basically brings the interests of each and every citizen of Cape Town into the picture. And the third thing that it does is to remove her from her governmental position of mayor of the city of Cape Town, to which she was duly elected by the council, not by her party, but by the council as a whole. And I will expand on those issues when I do my section. The last point by way of signposting that I really want to make, Justices, is that, and that will link up with what my learned friend Mr. Duval will outline as the history of this matter, is that, as a matter of principle, the applicant is here to seek justice. And in seeking justice, she symbolizes what we say to everyone, that you must, whenever you are in this kind of situation, resort to the courts, don't resort to self-help or other methods which might offend the law. Now, it does not matter what we might think of the current situation in the city, or the position of the mayor, or this particular mayor. The issue is what does the law compel us to do? The goddess of justice is blind for a particular reason, or so-called lady justice. So we can't have some rules for Ms. Lille and other rules for another mayor that we may or may not like. And I always make this point by putting more graphically by saying, using the examples of the presidents. We can't have certain rules for Nelson Mandela and other rules for Jacob Zuma, for example. Whatever our views might be on those two gentlemen. And I think that makes the point clear. And in order to preserve these things, you know, we come from a particular history where it was easy to make rules for certain people because they are black and others because they are white. And to undo that, we designed something called the Constitution. And the Constitution is there to be a bulwark to make sure that we apply justice blindly. And I'm saying this because the main thesis of our submissions is going to be that what has happened here in the past 10 days or so is really an insult to the intelligence of this court and the intelligence of the citizens of Cape Town, if not the country. Because it's merely a subterfuge which was designed to achieve that which could not be achieved by lawful means. And Mr. Duval will take you through the sordid history of this matter. But for my purposes now, I simply want to say that it's very clear that what happened is that the city had three options to do this. The first one was to do it lawfully by putting the motion of no confidence in the mayor before the city council. They did not take that option because it was taken before and it failed dismally. The second option that they had, where the illegality starts to border down, was to apply the so-called recall clause, or as we call it, the delete clause, in respect of which, simply by having the caucus or the party deciding that she must go, then she can be recalled. We sent them our papers as a matter of courtesy to indicate that that particular effort was going to be challenged very vigorously, because that clause is plainly unconstitutional. So the third option was...
Is the litigation pending in relation to the recall clause? Has that been initiated yet?
No, it was overtaken by events. That's exactly what happened. While purportedly the party was still taking legal advice on the forthcoming challenge, then this came into play. Now, this is very important, my lord. You might interpose what I would say is plan. So if plan A would have been to go to the council, maybe plan A2 would be to go to return to the council, and I use the word return advisedly. In other words, despite the fact that the motion might have failed in February, they could have gone back to it now, after they received our papers.
Sorry, Mr. Pope. I think you were also calculating these options.
Yes, I'm still there.
Oh, you're still there?
Yes. I'm kind of interposing a third option here. Remember, my lord, I said that the first one would have been the original one.
Yes.
Second one would have been the recall clause. I'm now saying the third one would have been a return to the council. Except, if you look at the papers, then you'll see why it is not return. It's very simple. They had, in fact, there's, in most cases, you don't get this. There's what one might call a smoking gun. It's at page 262 of the papers, where effectively Mr. Smith, who is the ringleader of the other side, explains to Mr. James South, who seems to be the embodiment of the party, that the caucus there today, that is 16th of April, felt that it should test, I'm sorry, I'm reading the last sentence of the first paragraph.
262?
262, I hope was not mixed up with the pagination. It should be an email.
LM1?
It should be an email from Jean-Pierre Smith. See that on the same page. All right, I don't have to go to it now. I'll just paraphrase because I'm just situating. It looks like there's a problem with the pagination. In any event, what I'm saying, Justice, is that in that email, the words...
I'm sorry, you're going to have to identify the documents.
Yeah, 247.
Yes, JS4.
That's correct. 247, I apologize. The first sentence of the email, I'm just reading the words. The caucus today felt that it should test the confidence in the mayor within the Cape Town DA caucus. In other words, there was now an attempt to return to the council. Except, of course, we now know that when that vote took place within the caucus, 97 councillors, 97 DA councillors voted in favor of it, and 41 voted against it, 41. What's the significance of that?
Sorry, just remind us, when was the recall clause
Promulgated.
passed by the Federal Congress?
The conference was on the 7th and 8th of April. 7th and 8th of April.
This is about a week later.
Literally a week later, it's being applied, and people wonder why it's called the delay clause. Now, what then happened there is very interesting, because we had this split 97 for, 51 against. Now, what that means is exactly this. Remember, the magic number is 116, because the councillors are 231. So you must pass 116, because there are 77 opposition members in total. So if you put 77...
How many opposition members?
77. Now, if you put the 77 opposition members and the 41, you get exactly 118. If you remove Mr. Lille from the picture for a minute, then you get 117, which means she would win the vote by 1 vote again. Which is exactly, so that option was not taken because it would have come to exactly the same outcome. Probably this time she would win by 2 votes because she would vote this time. She might. That's really why we're here. So now you're faced with this. The clause is unlawful. You can't go back to the council. So what do? You must dream up some fuss and some subterfuge to get rid of her.
So why do you say the clause is unlawful?
The recall clause, I've already covered that.
You mean it hasn't worked?
No. As I said, we serve the papers on them as a matter of courtesy, showing the grounds upon which the recall clause is unconstitutional. Right? What then happened, my lord, is that on the 4th or 5th of May, they came back to us and said, we are taking legal advice on what you have said in your papers.
Could I just ask you to stop for a moment there?
Yes.
It appears from the papers that a copy of intended court papers was served on the party sometime towards the end of last week.
Yes.
Thursday, on Friday or Saturday.
Yes.
And then they said they're taking legal advice. Are these the papers? Is it the founding affidavit in this matter that was served on them, or some other document?
No, of course not, my lord, because remember at that time it couldn't be these papers because what do you call it? This clause,
the recall
automatic cessation clause had not been invoked. So in reality, it's an adaptation of those papers, but obviously taking into account what had happened on the 8th. Yes. So that's the background. So everything you're going to hear then is...
The draft papers were intended to be an attack on
the recall clause.
The recall clause.
That's correct, Malik. That's correct. Because at that stage, that was the only... by the way, that also raises another interesting question, which will probably be ventilated fully in Part B. Namely, whether the same party can, at the same time, they received a so-called complaint on the 2nd on their version. And on the 4th and 5th, they tell us that they are taking legal advice on the recall clause. Have they not waived their right to enforce the so-called automatic cessation clause if they've conducted themselves as if they are pursuing the recall clause? But all those interesting matters will be dealt with in Part B. The only point I really want to make is that everything you're going to hear today is therefore the conduct of the DA in the pursuance of this, what I call subterfuge, to given the fact that all the proper legal avenues are closed, to just simply impose an unlawful mechanism to achieve the ends. And on that note, I will ask my learned friend, Mr. Deval, to take the court very briefly through the history of the matter and put those issues into perspective.
Yes, thank you.
Lords, just one qualification on what the leader said. I haven't been involved for 6 months only. I sometimes wish that was the case. It's more than 14 months, because, as I will explain very briefly, the history goes back further. Lord, I would like to spend 10 or 15 minutes at most on the background and just highlight a few phases for the purpose that Mr. Mpofu has already submitted to you. If one looks at the background, it is clear that the cessation clause was an option of last resort. It was used when the disciplinary process was perceived to have been driven into the sand by us complaining about the panel, wanting to have underlying documents such as SMSs and so on. It was used when the motion of no confidence in council failed on 15 February this year, and when it became clear after this Congress that it will fail again, it reinstituted. It was used after we served those draft papers on 4 May on the party dealing with the recall clause. And the argument was made, you cannot usurp the functions of the council by adopting internally for the party a recall clause and say that if the majority of DA councillors, not the majority of councillors in the city's council, but the majority of DA councillors decide we've lost confidence, then you de facto lose your membership of the party, which means that you lose the position of councillor. It is then in those circumstances that we submit that the clause that was ultimately invoked, section clause 3.5.1.2, was not invoked in a bona fide manner, and the discretion conferred by that clause was not exercised boni vire. I know that the DA says that there's no discretion, but we will show your lordships that there is certainly a discretion as to whether one wants to invoke this vague and general clause. And as any unilateral contractual discretion or right, it must be exercised boni vire. That's the one reason why the boni vire, my lord, as a reasonable person would. That's the one reason why we need to spend 10 minutes or 15 minutes on the history or the background. And the second one is, if one looks at what happened over the last 12 months, the DA cannot contend today that any harm would result if the mayor stays in her position, if the notice that they gave for the certification of the cessation clause is suspended for a period of 2 weeks. There will be no harm to the DA. There will in fact be no harm to the city. It's not for the DA to, of course, contend that there's harm to the city. It's for the city to say that. The city isn't so. So it affects the balance of convenience argument, which Mr. Mpofu will deal with. Because if you look at the history, it shows that there's not even an allegation of serious wrongdoing made against my client, our client, let alone a finding of any serious nature. It would have been different, perhaps, if the DA could contend this is a woman, a mayor, which has gone rogue and is corrupt or has been captured or something like that. But we know from the history that that is not what the situation is. There's never been an allegation that she's a mayor that's so bad, so corrupt, so captured, whatever the case may be, that she cannot stay on for that reason, let alone stay on for 2 weeks. Now, I will just highlight with reference to dates. Unfortunately, we didn't do a chronology. We may, if your Lordship would like to have a chronology, compile one at lunchtime.
I don't think it's necessary at this stage. It may be preferable in 2 weeks' time. But at the moment, we're dealing with whether there should be interim relief or not. So the focus is far from. I think you can attenuate your address accordingly.
As the court pleases. Lord, the background starts in January, February in 2017. This is the run-up to the provincial election for the new DA provincial leader. And we've highlighted there, this is the first time a complaint comes from the DA and where Mr. Lille is starting to face. Sorry, my lord.
The date again?
January, February 2017. That is what we call on the papers the Joshua Dance saga. This is the first time that the DA wants to act in a disciplinary way against Mr. Lille, and that is in the context of Mr. August and Mr. Kenton, Mr. August in particular, running for provincial leader. Now,
sorry, when was the provincial conference, congress?
25 February. It was in February, 25 February, if I'm correct, in 2017. And the argument is that she leaked a party document which basically outlines how you should get approval for expenditure. And the argument is that that contravenes somehow the DA's constitution, etc. But it takes place in the context where the report runs a front page article about the findings made against Mr. August that was running, it seemed to be aligned to Mr. Lille, against Mr. Matizela. It is in that context where the first disciplinary charges start. I'm going to leave it at that. Those charges are eventually not pursued. Next, we're dealing with the appointment of Mr. Steenhuisen in June 2017. Mr. Steenhuisen was appointed... Could I just stop you there?
Was there a leadership change at the provincial level at that time?
She resigned as provincial leader in the beginning of 2017.
So are you suggesting that the first DC was somehow linked to a leadership struggle?
Yes. My Lord, we haven't described that part of the history in detail in the papers, and that's why I'm not dealing with it. It's described in great detail in the Steenhuisen papers. What happened with this bizarre situation that a week before the provincial leadership enlisted, Ms. Gottsal tried to organize, Mr. Gottsal tried to organize a meeting with Mr. Lille, and she then says, I'm not available, I can only see you next week. And he says, no, that will then be moot because the leadership election is over the weekend. I need to come there before the election. Yes. Then we go into June 2017 when the Steenhuisen committee was appointed. And that committee
June 2017? Steenhuisen what?
The Steenhuisen committee was appointed, my lords. The committee was appointed to resolve tensions in the caucus of the City of Cape Town, the DA caucus. However, as we contend in another court case, the other court case pending before this court. Steenhuisen went way beyond his mandate, and he then made a series of findings against Mr. Lille. The entire report consists almost exclusively of findings against Mr. Lille. Some of them quite strange. For example, he finds that she somehow now took away the right of sub-councils to decide on planning matters. Of course, we know that the legislation changed, and it's actually the municipal planning bylaw and Spluma and Lupa that changed. Anyway.
May I just flag one issue? I have sat listening to the submission. I would, in your lordship, will have noticed this, point out that a significant proportion of what is being put up before your lordship is not on the papers, and demands to council effectively giving evidence in relation to that. I'm flagging that.
If your objection is noted, very honest, you are keep to the papers, please.
Yes.
Not to your personal recollection.
My Lords, but there are two disciplinary charges which emerge from Steenhuisen's report, ultimately finalized on 10 December 2017, and the mountain then gave birth to 2 mice in the form of disciplinary charges. Number 1,
Mountain gave birth to mice. Horrible.
perhaps with the noise about
So what are the two DCs that have mentioned this? Are they mentioned in the papers?
this is mentioned. The Steenhuisen committee, having listened to evidence from councillors and DA members, came up ultimately with a series of findings against Mr. Lille, but it only recommended that 2 disciplinary charges be instituted, and the one is an SMS that she sent, allegedly sent, in respect of the scoring of Mr. Ahmed Ibrahim, who was then a candidate for the position of Minister. Yes. Okay, Lord, maybe I should just broadly describe.
It's not in the papers, is it? The SMS.
The SMS is certainly on the papers, my Lord, in respect of, but we've been trying to get the SMS, as you know, and for the last perhaps 7 months.
Where is it referred to?
My Lord, may I then just park that issue? But there were two, by way of background, it produced these 2 charges.
Mr. Bob, there's been a fair objection to the fact that we're not sticking to the papers. We're sitting as an urgent court. You have to hear a lot of submissions still. Please just keep your argument focused on the papers, because we have to deal with it afterwards. And we consider judgment.
Yeah, my Lord, at page 21. I supposedly sent this SMS regarding the scoring of Mr. Ahmed Ibrahim in the title position of city manager. So,
Page 31.
21.
Paragraph.
Paragraph 31.6.
Thank you.
Lord, I'm going to cut this short, and provide you the background in broad strokes. There was an initial attempt in the context of provincial elections. Then there was the Steenhuisen Committee that was supposed to resolve the tensions. Steenhuisen brought out a report on 10 December 2017 in which he made some findings, including findings such as the SMS, which then were referred to the FLC ultimately for disciplinary charges to be brought against Mr. Law.
Did the Moorman DC then, was that constituted to deal with the Ibrahim SMS?
Yes, inter alia. It started with the SMS, but then further charges were added. Because the Bowman's report was then, you would have seen from the papers, my lord, that the Bowman's report from page 23 onwards, the Bowman's report came out at the end of December 2017, and these charges were then added from page 23 onwards. What they really involve is, again, allegations which we describe as very technical, certainly not the kind of allegations which would mean that the city would be harmed if my client were to remain in a position for 2 weeks. What Bowman's did was...
Did the Bowman's report lead to a new DC, or were those charges added to the Moorman DC?
Added to Moorman. In respect of Mr. Lowe, Bowman's made recommendations or investigating, still is investigating, 2 aspects. The Volvo bus chassis were paid for before the whole bus was received. So basically the city decided, in order to spend capital, it wanted to pay for the buses, the bus chassis as they were completed before the whole bus was delivered. Ms. Whitehead was then held accountable for this or responsible for this. Bowman's then recommended that she be referred to the City Council for investigations. And it's alleged that my client stopped that or tried to interfere with it. Not that she's got the power to refer Ms. Whitehead to the council. Mr. Ibrahim is at that time. Then the City Foreshore project. But again, these are not the kind of charges which would, we stress, even if proven, ultimately, necessarily result in Mr. Lowell being found to be corrupt in any way or incapable of proceeding. So these other charges were then added. By 15 February, however, 15 February this year, you would have seen from the papers, under the heading, Motion of No Confidence, you would have seen that then there was an attempt by the DA to bring a motion of no confidence in council against Mr. Law. And that's the motion that my learned friend has already referred to, which then failed with 1 vote.
What were the numbers there?
So no, page 16.
What were the numbers in the no confidence vote?
I think it was 109 versus 108, but yeah, it was 109 and 108 thereabouts.
110.
110 and 109.
Does so it failed by 1 vote. Does that split suggest that some members of the DA caucus would have voted against the motion?
No, definitely.
Sorry, some in favour of it and some against it.
Absolutely. The debate in the previous case when we were here, which resulted in the judgment of Mr. Justice Henny, was exactly about how the vote should take place so that DA councillors would feel free to vote against the motion. And in the end, the Speaker ruled that there should be an open vote, but nevertheless it failed. So just coming back to the broad strokes again, Steenhuisen's report resulted in disciplinary proceedings, and they were then added after Bowman's. By 15 February, however, there was a motion of no confidence this year, which failed. Right after that motion, the Moorman DC starts, or there's some pressure on us to agree timelines in order for the Moorman DC to start. There was from the beginning a demand from Mr. Lille that that hearing be one open and two before an independent person, an outsider, impartial and independent third party such as a retired judge, I believe there are many in Cape Town, or a senior advocate. And it is really those two demands of hers which have led to the disciplinary proceedings stalled, because when they were not conceded to, she took objections about the composition of the panel, the involvement of Ms. Breitenbach as both committee assistant and FLC chair. She wanted to see the SMS. I mean, it is asking too much. She wanted to see the SMS as the evidence before she go and defend herself to that charge that she gave this instruction about the scoring of Mr. Ibrahim. And those points were taken by her during the initial hearing that took place before Mr. Hans-Louis Moorman, which was between 20 and 22 March. You would see from the papers that what then happened is that one of the issues was whether the panel members, Ms. Kammerer and Mr. Monchusi, should recuse themselves.
Is this relevant at this stage?
It is relevant in the sense that the reason why, as we said at the outset, the reason why the DA is elected to invoke the cessation clause is because those disciplinary hearings are basically stalled because of the two demands that Mr. Lille made, which are not, that's why we say in the papers, if the DA is prepared to grant Mr. Lille an open hearing, an open disciplinary hearing, not a secret, private, in-camera one. Number two, if they're prepared to appoint an impartial person, then that whole process could take 1 month, less than that. But from our point of view, we are bound to take these points which have derailed those proceedings for the very reason that the demands on those two basic demands aren't met. Lord Moorman DC then came to an end basically on the preliminary points at the 22nd of March. We're still waiting for judgment on many of those points. He has decided not to allow us to have an open hearing. But then what happened is that there was a second disciplinary process that was started, which we refer to as the Ubad hearing. On the 22nd, as the Moorman hearing was drawing to a close, my attorney was handed a further charge sheet, you would recall from the papers, to appear before a separate disciplinary a week later. 22nd of March was the last day of the Moorman hearing. To appear on the 3rd of April before a separate disciplinary hearing on one other charge. Now, it's not clear to us why that wasn't added to the Moorman DC, other than that it's an abusive process, that it was done purely in order to ruin her financially. So the second hearing before Mr. Len Ubad then started on the 3rd of April with one single charge, which in fact, if you look at page 157 of the papers, 157. Perhaps we can go there, because at page 157 you'd see the independent investigators, as now Cliff Decker attorneys, Mr. Stansfield and Mr. Singh. You'll see at page 157, paragraph 5.2. This is the finding that has already been made about this. It said, in relation to the comments made in respect of the Executive Mayor during Skipper's evidence at arbitration and the summary reflected in the award, we find no evidence during our investigation that the Executive Mayor played any role in either the shortlisting or subsequent appointments before direct. But that's now the charge that we're still facing. And of course for the city it's quite difficult, for the DA it's quite difficult, because it constantly has to get the documents that the city has got from Bowman's, from Cliff Decker and so on, and then it wants to replicate disciplinary charges and hearings in its own processes. So on this one it is behind the curve.
The document at page 157 commenced at 155. It's dated the 18th of April. This is an investigation by attorneys at the request of the city.
Yes. But as we say in the papers, Mr. Bagram is now trying to arrange for us to have this disciplinary continuing. Well, this was at least until the automatic cessation clause, but the charge has already been effectively found to have no merit by the city's own investigators. So what we had was the motion of no confidence in February. We had the Moelman inquiry 20 to 22 March. Then we have the Joubert inquiry about the separate charge in April. And then we find the Congress between 7 and 8 April, where the recall clause was approved. Now, Mr. Mpofu has already dealt with the recall clause, and I'll be brief, because as your Lordship already noted, that clause was sought to be invoked about a week or 8 days, 8 days after it was adopted on 16 April, Mr. Smith writes, asking for permission for the internal motion of no confidence. The internal motion of no confidence then succeeds 97 to 41, but we mustn't forget about the 15 that stayed, that absented from voting. So it isn't necessarily only 97-41. But it's clear that the 116 vote, the threshold was never going to be reached. We made representations regarding the implementation of the recall clause on the 2nd of May. Then the weekend follows 4-5 May, in which they sit FedEx for the first time after the Federal Congress. They apparently then decided that because we sent draft court papers, they need legal advice, and then ultimately never invokes the recall clause. But on Tuesday morning this week, at 7:52 in the morning, the automatic cessation clause letter is then delivered by email to Mr. Law. My Lords, now I would like to elaborate on how the cessation clause works and our sufficiency. If I can take you to page 76.
If you're going on to a new point, perhaps we should take a 10-minute